Welcome everyone, and thank you for attending the 11th annual session of the CHC Supreme Court. Will you all please rise for the playing of our national anthem? This year's lawyers are Caroline Dixon, Ben Schwantes, Flynn Summers, Stephanie Sherlin, Jasmine Zhang. They will be arguing the case of Mitchell v. Wisconsin and Rahaith v. United States. To the 9 justices for today, the Mitchell case raises the question of whether the state of Wisconsin was permitted to take a warrantless blood draw from an unconscious drunk driving suspect. The Rahaith case raises the question of whether the government is required to prove that an illegal immigrant knew he was illegal in order to convict him for possession of a handgun and ammunition. As a tryout, all 5 students have prepared a 5-minute argument for Mr. Facemeyer and Mr. McGraw on behalf of Mr. Mitchell. Since being chosen, they have gone through hours of practice in front of previous student lawyers, their peers, and local attorneys to prepare for today. And yesterday, they saw these cases argued at the United States Supreme Court in Washington, D.C. Now, Tracy Gong and Carissa Jang will give you a short presentation about the facts of the case and the legal arguments you will hear tonight.
Mitchell versus Wisconsin. Facts of the case. In May 2013, Gerald P. Mitchell was arrested for operating a vehicle while intoxicated. When Mitchell became lethargic at the police station, the police took him into a hospital. At the hospital, Mitchell passed out, and while he was unconscious, the police directed hospital workers to draw his blood. A test of the blood sample revealed that Mitchell's blood alcohol concentration was 0.222. Despite the fact that the police did not have a warrant to take the blood test, the results were admitted into evidence at trial and shown to the jury. The jury found Mitchell guilty of drunk driving. Question for the court: did the police violate the Fourth Amendment by drawing blood from an unconscious person without getting a warrant first? The Constitution. First, the Fourth Amendment prohibits unreasonable searches. Usually, this means police must obtain a warrant before conducting a search. However, no warrant is needed if a person consents to the search. The implied consent law. A Wisconsin law states, first, anyone driving on a Wisconsin road gives the police implied consent to do a blood test. A driver can, however, withdraw his or her consent before the blood is taken. Third, an unconscious person is deemed not to have withdrawn consent. Arguments for Mitchell. First, the implied consent that arises from the statute is not free and voluntary consent. Second, Mitchell had no chance to revoke his consent because he was unconscious. Third, the state cannot condition the issuance of a license upon the waiver of a constitutional right. Fourth, while blood draw is a significant bodily intrusion, getting a warrant would have been easy. Argument for Wisconsin. First, the Wisconsin implied consent statute is the kind of statute that the court has favored in the past. Second, the consent that arises from the statute is still valid even if Mitchell was unconscious. Third, driving is a privilege, not a right, and the state can place conditions upon that privilege. Fourth, getting a warrant can be problematic in cases involving unconscious people.
Rehave v. United States. Facts of the case. Hamid Mohammed Ahmad Ali Rehave, a citizen of the United Arab Emirates, came to the U.S. on a student visa but was later dismissed from school. As a result of the dismissal, his status changed from legal to illegal, although Rehave claims that he was never informed of this. Rehave was later arrested and charged with a violation of the Firearm Owners Protection Act because he had a bullet in his hotel room and because he fired a shotgun at a firing range. Both of these acts would have been permitted if he had still been in the country legally. Rehave was convicted and sentenced to 18 months in prison and was subsequently deported. Nevertheless, he has appealed this case to the Supreme Court, arguing that he could not be found guilty under FOPA if he did not know that his immigration status has changed. The question for the court is that to convict someone under FOPA, does the government need to prove that the defendants knew he was illegally in the country? Or is it sufficient for the government to prove that he was illegal and that he knew he possessed weapons? Section 922G of FOPA states that it should be unlawful for any person who is illegally or unlawfully in the United States to possess any firearm or ammunition. Section 924A2 of FOPA. Whoever knowingly violates subsection G of Section 92 should be fined as provided in this title, imprisoned not more than 10 years or both. Arguments for Rehave. First, the plain language of 92G and 94A suggests that the knowingly violates phrase applies to each element of the crime. Second, when Congress passed a law, it included the phrase knowingly to prevent people from being punished for making innocent mistakes. Third, if a criminal statute is ambiguous, courts should interpret in a way that favors the defendant. Last, Rehave was understandably confused about his status. Arguments for the United States. Congress included a state of mind, mens rea component in other parts of FOPA, but not in 92G. Therefore, they must not have wanted one there. Second, Congress intended to write into law previous judicial decisions, holding that the government does not need to prove knowledge of status. Third, it's very difficult for the government to prove knowledge of status. Last, the evidence suggested that the Rehave did, in fact, know that he was illegal.
is going to reveal the results of a survey that he and fellow AP government student Mitchell Kuthiero gave to the Cape Henry Upper School students about issues in the case.
We took a survey. We sent a whole survey out to the upper school about some issues of the case, and we just wanted to present these survey results to you.
All right, so these are some general questions about the upper school students who responded to the survey. First, we asked, what grade are you in? And out of 138 responses, 54 of these responses were from the senior class, 43 were from juniors, 18 were from sophomores, and 23 were from freshmen. Out of 138 responses, these were split 50-50 when it came to gender. So half male, half female. And these are the results regarding to questions relating to Mitchell versus Wisconsin. So the first question was, if the police suspect you drunk driving, should they be able to take your blood without getting a warrant from the judge? 75% of the upper school student responses said that no, they should not be able to take your take your blood without a warrant, and roughly 25% said yes. Next question says, if the police suspect you of drunk driving, should they be able to make you take a breath test without getting a warrant from a judge? And this had quite opposite results. It said 86.2% of the student body said yes, they should be able to have a breathalyzer test, and 13.8% said no.
All right. Here is the results of those questions, just broken down by grade level. So the first one pertains to the blood without a warrant, and broken down by grade level. Each grade level thinks that generally, no, we need to get a warrant from a judge. I'd say the most drastic difference is between seniors and the senior. The majority of the seniors said that you do need a warrant to get blood drawn. And then this is for the other question. And yeah, it speaks for itself. So this is the United States case.
Okay, so first question, should illegal immigrants be allowed to own a gun? This one came back pretty unanimous at 94.2% of people saying no, and just 5.8% saying yes. This question, if not, what if the illegal immigrant did not know he was illegal? For example, he was here legally, but was never informed that his visa expired. Should the government prosecute him anyways? 54% of the responses said no, the government should not prosecute him, and 46 said yes. So this was split pretty evenly.
And then these are the same questions, just broken down by grade. First one is, should illegal immigrants be allowed to own a gun? Every grade is pretty much the same results, just no. And then this is the second question. If they did not know they were legal, like let's say they didn't know their visa expired, should the government prosecute them anyway? And that's a pretty mixed opinion for both grades, or all grades, sorry. And then thank you.
Thank you.
Now it is time to get to the arguments. The lawyers will argue their side of the case in front of the 9 justices for 10 minutes each. The justices will interrupt the students with questions about the case, and the students are expected to answer on the spot within the time provided. First, Stephanie Strickland will argue on behalf of petitioner Gerald Mitchell. Please stand. Second, Caroline Dixon will argue on behalf of the state of Wisconsin. Third, Ben Schwantes will argue on behalf of Mothers Against Drunk Driving in support of the state of Wisconsin. Fourth, Flynn Summers will argue on behalf of petitioner Mohammed Rahif. Finally, Jasmine Zhang will argue on behalf of the United States. After all the student lawyers have finished their arguments, the justices will then hold a short conference to vote on the cases, and then, over the next few weeks, they will write 2 opinions announcing and explaining their decision. During this time, the students will not know who won. They must wait until the opinion is released.
The 9 justices in the case are Chief Justice the Honorable Pamela E. Hutchins, is a former judge of Virginia Beach General District Court and is now an adjunct professor at the Marshall Wythe School of Law at the College of William and Mary.
Michael Allen is a Cape Henry senior and participated as a student lawyer in last year's program. He plans to attend Washington University in the fall.
Charlotte Brown is a Cape Henry senior and participated as a student lawyer in last year's program. She plans to attend the University of Michigan in the fall.
Alex Castellano graduated from Cape Henry in 2011 and practices law at Wolcott River Gates in Virginia Beach.
Dr. Christopher Guerin currently serves as Cape Henry's 11th head of school and president and is also a Cape Henry parent.
Lee Gregory teaches chemistry in the Cape Henry Upper School and is also an attorney specializing in patent law.
Paul Horgan is both the director of Cape Henry Upper School and a senior associate college counselor. He is also a Cape Henry parent.
Wendy McGraw practices law at Hutton Andrews Kurth LLP in Norfolk and is also a Cape Henry parent.
Kim Shepard practices law at Jones Walker and May PC in Virginia Beach and is a Cape Henry parent.
All rise.
Oyez, oyez, oyez. The Cape Henry Supreme Court is now in session. God save Cape Henry and God save this honorable court.
Okay, now we're ready to begin the arguments.
Good evening. I understand on tonight's docket we have 2 cases. Are the parties ready to proceed? Proceed, ma'am.
Ms. Chief Justice, may it please the Court, my name is Stephanie Strickland and I'm representing the petitioner, Gerald P. Mitchell. The petitioner respectfully requests the Supreme Court to overturn the decision of the Supreme Court of Wisconsin for 3 reasons. First, Mitchell never consented to the blood draw. Second, requiring someone to give up their constitutional right in order to obtain a license is unjust. And third, the police could have easily obtained a warrant from the city. My client was arrested in May 2013 for suspected driving while under the influence. He was taken to a holding cell where he appeared tired but full of stimulation. Once he was transferred to the hospital for a blood draw, my client was completely passed out. The police even went as far as to read him his consent form for the blood draw while he was unconscious, which my client could not understand. He did not acknowledge or respond to this consent form.
Counselor, under the Wisconsin law, consent is implied, and as a part of the privilege to drive in Wisconsin, that consent is implied. So he's already given his consent by virtue of the fact he got a driver's license in that state. How do you rebut that?
The implied consent law does not hold up here because implied consent is not real consent in this case. This court has held that in the case of Bunker v. North Carolina, consent must be freely and voluntarily given. When someone's unconscious, they can't freely or voluntarily give consent. Further, this court has held in the case of Florida v. Jimno that private consent based on
Counselor, if your client had signed something at the DMV when he got his license that's
that acknowledged that he was consenting to a blood draw if he was driving on the roads. Would that change the outcome here?
No, because in the case of Florida v. Jimnell, as I was stating earlier, it states that a search in reliance upon the earlier consent is not a justification for search. So because he was unconscious during the time of the blood draw, that is not real consent. Just because he consented when applying for the license does not mean he consented while the blood is being taken. This court also established that a suspect may of course do limit as he chooses the scope of the search to which he consents in Florida v. Jimnell. And my client was unable to revoke his consent at any point during the blood draw as he was unconscious.
Well, Counselor, the reason he was unable to consent is he drank himself past the point of consciousness, correct?
Yes, but it is not the fault of the petitioner in this case. We're looking at the implied consent statute, which is unconstitutional because it places an exceedingly unreasonable condition on driving. And that is, the court has already established in the case of Birchfield that a blood test is a significant invasion of privacy and that police must apply for a warrant if they need to perform the blood test.
Counselor, I understand that as a general proposition, but here, once he goes to the hospital is going to draw his blood anyway as part of the medical treatment. So what's the harm?
Yes, so the hospital can perform a blood test, but in order for the police officers to get access to that blood test, they still need to apply for a warrant because it is going against Mitchell's constitutional rights. The Fourth Amendment states that citizens are protected against unreasonable searches and seizures. So if the medical staff were to perform their own blood draw, then the police could only access that blood draw after applying for a warrant, where a judge deems there was probable cause for them to use that evidence. The state tried to justify their warrantless blood test by stating that the opportunity to refuse at the scene was not of constitutional significance. But motorists can refuse a blood test when they're pulled over. In fact, a study done in New Hampshire found that 22.4% of suspected DWI offenders refused to partake in BAC testing. So if he had been conscious, then he would have been given the opportunity to revoke his consent or either deny or accept. And then,
so, Counselor, if we agree with you, do you think that we're opening up or setting sort of a dangerous precedent in that couldn't drunk drivers just pretend to be unconscious and thereby say, I never consented, you can't draw my blood or take a breath test or anything?
someone could do that. But if someone was pretending to be unconscious, and then if you decided with Mitchell on this case, the police officers would then go and apply for a warrant, which is the same thing they would do if the person was conscious. Apply for the warrant, and then the judge would either grant it or not based on if there was probable cause. So I don't think someone pretending to be conscious.
But Counselor, wouldn't it take an extended period of time for the judge to actually get the warrant? So wouldn't that affect the arrested person's blood alcohol content?
No. First of all, in the case of Missouri v. McNeely, the court has already established that exigent circumstances do not permit a warrantless blood draw. And further, in that case, the court stated that recent technology allows police officers to obtain warrants remotely by means of telephone, fax, or email. In a study done on 8,400 warrants taken in 12 months, the study found that one was granted only 38 seconds after it was requested electronically. Out of those 8,400, 4,200 were granted in less than 10 minutes. So the state had ample time to apply for and receive a warrant in this instance. So time is not a justifiable excuse for going ahead with the blood draw without a warrant, as they are very easy to obtain.
And it'd be easy in some of these bigger cities where there's lots of judges and quick to get a warrant, but won't our decision also impact those small towns with maybe one judge who's asleep on a Friday night? In those towns, it'll take much more than 30 minutes.
Yes. So if there was a judge that was not on call, then the police could take the blood and argue the exigent circumstances after the fact, stating that they couldn't get a hold of the judge, couldn't get the warrant, therefore there was an exception and they could have taken the blood. But in this case, the police did not argue exigency and instead solely cited the implied consent statute for reason for taking the blood. So if there was no officer available, they could argue exigency, but in Mitchell's case, they did not.
But Counselor, let's return to the decisions made by the petitioner, which is that he chose to drink himself to a condition that he thereby forfeited his right under the law to withdraw his consent, because under the current law, does he not have the right to withdraw his consent if he's suspiciously intoxicated but conscious enough to communicate with law enforcement?
Yes.
He has the right to withdraw.
Yes, he does have the right to withdraw. So my client was not given the right to withdraw because he was unconscious.
Aren't there similar situations if he had been going in for surgery? He would have given his consent for the surgery, then he would have been under anesthesia and could not withdraw that consent. And yet, there would not be a problem with proceeding with the surgery.
Yes, but in any medical situation, implied consent is different because it's presumed to benefit the person who is getting the surgery. In this case, the warrantless blood test was used against my client as evidence in trial. So in the medical situation, it only can benefit him because he was getting the surgery. But in this case, they're holding it against him. And so it should be up to a magistrate to determine whether or not there was probable cause for the police officer to seize the evidence. The states have tried 2 other times to intentionally disregard the Fourth Amendment, and the court has struck it down both times. Mitchell v. Wisconsin is just a 3rd attempt by the states to abuse their power, violating the Constitution in drunk driving incidents. The case of Birchfield v. North Dakota weighed the burden on states versus the individual and found that a breathalyzer is not a significant invasion of privacy, but instead called a blood test a significant intrusion in which police must apply for a warrant if they want to take the blood test. They found that the breath test is in the state's interest above the individual's privacy, but instead the blood test, the individual's privacy outweighs the state interest because it is such a significant invasion of privacy.
Counselor, what's the harm in just carving out a very limited exception here for unconscious drivers, where we allow the blood draw?
Are you asking why it is okay that they don't need a warrant in case?
Yeah, I mean, we're not opening up the floodgates of unreasonable searches if we narrow this, tailor it to a driver who is found unconscious. Only in that circumstance are we going to allow a warrantless blood draw, assuming the state has one of these implied consent statutes.
Yes, but when states start placing unreasonable conditions on driving, it opens the door for other rights to be taken from citizens, like freedom of speech and freedom of religion. The protection against unreasonable searches and seizures have been in the Constitution. And so, when the police start taking people's rights away, it could just snowball, go on, and they could start placing other exceedingly unreasonable conditions. For the foregoing reasons, the petitioner respectfully requests the Supreme Court to overturn this.
Thank you.
Ms. Chief Justice, may it please the Court, my name is Caroline Nixon, and I'm representing the state of Wisconsin. The defendant respectfully requests this Court to overturn the decision of the Supreme Court of Wisconsin, to uphold the decision of the Supreme Court of Wisconsin. The Court should uphold this decision for the following reasons. 1, the blood draw performed on Mitchell was not a violation of the Fourth Amendment. It was consistent with previous rulings of the Court and the Wisconsin implied consent statute, as well as subject to the exclusionary rule where a warrant is not necessary. Gerald P. Mitchell was charged with the 7th drunk driving offense after heading to Lake Michigan in a severely intoxicated state. At trial in the Supreme Court of Wisconsin, petitioner admitted that he was headed to Lake Michigan with 40 pills and a mixture of half a liter of vodka and Mountain Dew. Authorities found Mitchell, and he was taken into police custody, where police took him to the hospital on grounds of medical concern, and the hospital staff administered a blood test, which showed an indismissible blood alcohol content of 0.222. where the Wisconsin blood alcohol limit to drive is 0.08. Once again, this is Mitchell's 7th drunk driving conviction. He clearly understood the laws and stakes at hand, but selfishly ignored these laws, putting the lives of his fellow citizens in grave danger.
But Counselor, isn't there a law already out there wherein the officers who had taken him into custody could have gone and gotten a warrant, and we wouldn't be here today?
Yes, the police could have gotten a warrant, but the police needed time to access the unconscious driver's state and any injuries to others and to secure the scene. This delay means evidence is quickly disappearing, and in these cases, any time lost may lead to serious medical consequences for the unconscious driver. An officer should be able to focus on that and not on obtaining a warrant that will serve no valid purpose. The search of an unconscious impaired driver was valid under the consent exception. The court has ruled in both Fernandez v. California and Shanklock v. Bustamante that warrantless consent searches are reasonable, and therefore they are consistent with the Fourth Amendment.
Counselor, we heard from Mitchell's attorney that it's quite easy to get a warrant. It takes 38 seconds in some instances, 10 minutes in others. What's your response to that?
Well, although some warrants are becoming more easily acceptable, this court's decision affects every county in the United States. And smaller counties where warrants may not be so easily accounted for and accessible must be accounted for as well. An arrest warrant may take as little as 1 or 2 business days, which is very rare, or can be as long as a few months. And a typical arrest warrant in a very small county has been proven to have been issued within around a week of a DA's request, which by that time, obviously, the blood alcohol content would have been diminished. In the case of the unconscious driver, a blood test is necessary to avoid the destruction of evidence. At the same time, a warrant requirement unreasonably risks delaying medical care for the impaired driver. The exigencies of the situation so presented render the warrantless blood draw objectively reasonable under the Fourth Amendment. It may try to be argued that police already had results from a breathalyzer. However, results obtained from a breathalyzer cannot be used in court in the state of Wisconsin. The police needed to draw blood from petitioner, and there was no time for a warrant, as the alcohol content was quickly leaving his bloodstream. A warrant in this case was not even necessary in the first place. A Wisconsin statute provides, in relevant part, implied consent. Any person who operates a motor vehicle upon the public highways of Wisconsin is deemed to have given consent to 1 or more tests of his or her breath, blood, or urine for the purpose of determining the presence or quantity of alcohol, controlled substances, other drugs, or a combination of these factors when requested to do so by a law enforcement officer. This Wisconsin consent law is not unique in its kind. Rather, almost all states have this type of implied consent law to prevent drunk driving, which brings on many types of consequences, ranging from thousands of lives being taken, many more injured, and billions of dollars worth of property damage each year.
I'm sorry, go ahead. Wouldn't we be rewarding Mr. Mitchell by granting his petition? And it was his own conduct by which it led to his inability to withdraw his consent because he was passed out. We
Yes.
keep calling him unconscious. He was passed out drunk. How do we avoid rewarding his bad behavior?
You avoid rewarding his bad behavior by upholding the Supreme Court of Wisconsin's decision. And the unconscious intoxicated motorist already has this implied consent, and he may either before he becomes unconscious or if he awakens withdraw this consent, but the Constitution does not require a state to afford the opportunity for him to withdraw it. And as we previously said when Stephanie was presenting, that a driver might pretend to be unconscious to avoid this blood draw. And that cannot happen, as there are many, many cases of drunk driving in the United States every year. And on average, there are about 200 alcohol-related fatalities in Wisconsin yearly between 2011 and 2015, and an average of 2,800 alcohol-related injuries each year. And
What is your response to the argument that this is not a knowing and voluntary consent?
Yes, in Birchfield, the court said that it is well established that a search is reasonable when the subject consents, and that sometimes consent to search does not need to be expressed, but may be fairly inferred from context. And in determining whether consent is given, a 2-step process is used, which was outlined in State v. Arctic, which is relevant words, gestures, or conduct supports a finding of consent. In Mitchell's case, his relevant gesture was his decision to step into the car completely intoxicated and decided to drive, putting people's lives at risk. And according to State v. Phillips, consent to search does not need to be given verbally. The voluntariness of the consent to testing is best understood to occur not during the interactions with the police, but instead during the whole voluntary act of driving. This implied consent statute is more simply explained in Jardins v. Florida, where the court recognized that by putting a doorbell on the door, a homeowner implied consent for someone to come onto their property and ring it. This consent is complete at the moment the driver begins to operate a vehicle on Wisconsin Road, where the driver evidences probable cause to believe that he or she is operating the vehicle while intoxicated. Mitchell cannot withdraw his consent. He is unconscious, and that is his fault to begin with.
Counselor, what is the hospital's policy when any patient is brought in unconscious regarding a blood draw? Wouldn't that be a standard
Yes.
thing to do when a person comes in passed out
Yes.
with unknown substance, alcohol or otherwise?
Yes, that is a standard medical procedure, and in fact, this court long ago ruled that blood testing procedures have become routine in our everyday life. Extraction of blood samples for testing remains commonplace in these days of periodic physical examination, and this procedure involves virtually no risk, trauma, or pain. The blood test would have been administered anyway by the hospital staff, as you pointed out, and to figure out how to treat the patient. If the police did apply for a warrant and receive this blood draw, there would need to be another blood draw that occurred, putting another needle into the patient and violating privacy further. Furthermore, driving is a privilege, not a right. The license and the blood test directly correlate. This is why if you refuse to take any test that police require, your operating privilege will be revoked and you will be subject to other penalties. The test results, or the fact that you refuse testing, can be used against you in court. The Supreme Court case of South Dakota recognizes that a person suspected of drunk driving has no constitutional right to refuse a blood alcohol test, and a driver's refusal could be used against him at trial as evidence of guilt. In Abram, this court held that a warrantless blood draw from an unconscious impaired driver does not in fact violate due process. And if this court chooses not to believe that the driver was given implied consent, then Fernandez v. California and Shanklock v. Bustamante still hold that warrantless consent searches are reasonable and therefore consistent with the Fourth Amendment. And the Circuit Court of the United States ruled on the search of passengers in airports back in 1973, which effectively suspends limited aspects of the Fourth Amendment while undergoing airport security screening. In the Ninth Court rules on U.S. v. Davis, noting that airport screenings are considered to be administrative searches because they are conducted as part of a general regulatory scheme where the essential administrative purpose is to prevent the carrying of weapons or explosives aboard aircraft.
Counselor, does this statute have a probable cause requirement for the blood draw?
Yes, it does.
And in this case, what was the officer's probable cause?
The officer's probable cause was there was a phone call from Mitchell's neighbor that called concerned that said that he saw Mitchell stumbling to his car, barely able to stand up, tried to speak to him. His speech was slurred. He was obviously intoxicated and got in the car and drove away. That was their probable cause. And drunk driving, as well as these TSA airport searches, is extreme danger as well as the weapons on aboard these aircraft. And drunk driving occurs much more frequently, begging to be addressed. This is not Mitchell's first offense, but rather his 7th drunk driving offense. The Wisconsin implied consent statute only deals with intoxicated drivers. We are not opening up searches for all types of implied consent, nor I nor the state of Wisconsin are arguing for implied consent of any type. As I think we can all agree that taking something, let's say a kidney from an unconscious driver suspected of a DUI would be extreme and a total violation of the Fourth Amendment. Blood, not so much. Not only government interest is at stake here, but the interest of the people compared to the individual unconscious intoxicated motorist is far greater. There must be something done to dramatically reduce these numbers and hold the drunk drivers responsible for their actions within constitutional limits. For the reasons above, the decision of the Supreme Court of Wisconsin should be upheld.
Mr. Chief Justice, may it please the Court, my name is Benjamin Fontes, and I'm representing Mothers Against Drunk Driving. Mothers Against Drunk Driving respectfully requests this Court to uphold the decision of the Supreme Court of Wisconsin. The ultimate goal of Mothers Against Drunk Driving is to keep all drunk drivers off the road by any reasonable means, to prevent families from being destroyed by an intoxicated person behind the wheel of a several thousand-pound vehicle. In the process of removing these drivers from the road comes the need to prosecute them and put them behind bars, meaning evidence will need to be provided, typically a BAC. If the driver is so intoxicated that he or she becomes unconscious, the police are allowed to proceed with a warrantless blood draw to obtain the BAC because the search is reasonable. This type of search is reasonable because there is no less invasive alternative. With the intoxicated driver unconscious, the subject can't perform the standard breathalyzer test. There is a third alternative to obtaining a BAC, that being a urine test, but that option is also unavailable because the unconscious subject can't perform a urine test. And even if the subject were able to, they're far less accurate compared to a blood draw. Studies have shown that the poor accuracy of a urine test can lead to a BAC being lower of the actual BAC of the subject. This could lead to an intoxicated person not being convicted and going back out just to wander into another bar, get drunk, behind the wheel of a vehicle, and kill someone. The blood test is the only choice in these circumstances and is a reasonable search as it's just obtaining blood, something a doctor might do annually for their patients. Furthermore, obtaining a warrant adds no additional protections to the process. If the authorities manage to obtain a warrant for the search, they would proceed with drawing blood from the unconscious subject and obtain a BAC. If the authorities don't need a warrant, they can proceed with the blood draw without waiting for a judge to sign off on a warrant and obtain a BAC. Notice how under those two different scenarios, the end product was the same. A BAC was obtained and can now be used to put a drunk driver in prison. The difference is the first scenario required authorities to have an additional burden placed on them without any significant benefit. While in the second scenario, the authorities are able to complete the blood draw in an efficient process. The police should not have the burden of a warrant placed on them if there is no benefit to be had in these circumstances. An argument against this might be that the warrant is meant to protect an individual's rights, and that is a valid argument, but not under these circumstances. If a driver has decided to consume alcohol and get behind the wheel of a vehicle, then he has a diminished expectation of privacy, especially if he has consumed so much alcohol that he becomes unconscious. We have all heard this phrase at least once in our lives. The needs of the many outweigh the needs of the few. The few in these circumstances is a single drunk driver whose need is to have his privacy upheld. The many is the public. Their need is to remain safe and free of harm from someone such as a drunk driver. Any reasonable person can agree that if these needs are weighed against each other, the need of the public will come up on top by a landslide. A driver who drinks so much that he becomes intoxicated should not have his privacy upheld, and a warrant should not be needed to protect a person who is only concerned about himself and not the people around him. Finally, the lack of a warrant is acceptable because the states have an interest in keeping the public safe. The need for the public to remain safe has already been discussed. Now how to do that shall be addressed. Shall a warrantless blood draw be found constitutional? The states will be able to remove more drunk drivers from the road and prevent them from destroying the lives of innocent people. In 2017, 10,874 people died in drunk driving crashes. That's one every 48 minutes. Of that number, 220 were children of age 14 and under. In the same year, over 300,000 people were injured in drunk driving crashes. Every day in the U.S., another 30 people die as a result of drunk driving crashes. The need to remove drunk drivers from the road is one that should be placed on the top list of priorities, and a warrantless blood draw can help remove these selfish beings from the road and keep our loved ones safe. For the foregoing reasons, Mothers Against Drunk Driving respectfully request this court to uphold this decision of the Supreme Court of Wisconsin.
Madam Chief Justice, the petitioner further respectfully requests the Supreme Court to overturn the decision of the Supreme Court of Wisconsin. The court has already established that a blood test is a significant intrusion and it does not need to be argued again. Caroline argued that there is no reason not to obtain a warrant, but in this instance there is no reason to obtain a warrant, but in this instance there is no reason not to obtain a warrant. A warrant protects an individual's Fourth Amendment rights, which have been violated with this implied consent statute. Exigency has already been argued, warrantless blood tests have already been argued, and the court has overturned both. The implied consent statute doesn't allow my clients to give consent freely, and it is not a reasonable condition placed on driving. And further, implying consent to someone ringing your doorbell is different than implying consent for your DNA to be forcibly removed and used as evidence in court against you. Overall, this was not consent, as my client was unconscious, and forcing someone to give up their Fourth Amendment rights to privacy is unconstitutional. Move on. And finally, obtaining warrant is easy and the police should have done so in this instance in order to protect my client's rights. For the foregoing reasons, the petitioner respectfully requests that the Supreme Court overturn this decision. Thank you.
Counselors?
Madam Chief Justice, may it please the court, my name is Flint Summers, and I am representing Mr. Rehife. I respectfully request this court to overturn the decision of the Court of Appeals. I will address 5 reasons as to why Mr. Rehife and the defense should win this case. Firstly, the plain text and structure of these provisions make clear that knowingly violates applies to both the status and possession elements of the statute. Secondly, the reading of the plain text is consistent with this court's treatment of mens rea requirements in criminal statutes. Thirdly, Mr. Rehife's reading of knowingly violates is consistent with the history and purpose of the Firearm Owners Protection Act. Fourthly, requiring the government to prove that a defendant knew of his or her status at the time of the possession of the firearm avoids due process concerns. And lastly, the rule of lenity resolves any ambiguity in Mr. Rehife's favor, meaning that the tie should go to the defendant. Regarding my first reason, the starting point for any statutory interpretation is the language of that statute itself. And when that language is made clear and plain, the only role of the court is to enforce it. Had Congress intended for knowingly violates to only apply to the possession element of the statute, they simply would have placed knowingly violates right before possession. But this is not what they did, because this is not what they intended. They placed knowingly violates before status as well as possession. The idea that somehow knowingly violates skips over status and only applies to the possession is absurd. And this is seen in the case of U.S. v. James Perez, where then Judge, now Justice Gorsuch himself declared that the plain language of the statutes should require the mens rea of knowingly violates to apply to both non-jurisdictional elements of the offense. He went as far as to state that it defies linguistic sense for knowingly to apply to the possession of the firearm, but not the status of the possessor, which makes that very possession illegal.
Counselor, even if we agree with your argument that that your client need not know, how do we prove that? It's almost impossible to prove someone else's knowledge.
In this case, in this particular case, there was evidence on both sides. In the district court, the government instructed the jury to not consider that the government had to prove that Mr. Rehife knew of his status. However, there was evidence such as FIT, the school that he went to, had emailed him. There was evidence from an FBI interview, but I'd also like to point out there was evidence on Mr. Rehife's side that after his information was changed by the SCVP of the Homeland Security Department, he went out and obtained a hunting license, which if he knew he was illegal, he would not have been able to obtain. So there's evidence on both sides. I would have suggested that the government use this evidence and let the jury would filter out the truth, which is the purpose of the jury.
So, Counselor, presumably your client knew that he was here on a student visa, and you said that he was made aware that his student visa was revoked. Are you saying that that's not sufficient evidence for your client to understand, okay, I'm no longer here legally if the reason he came here was on that student visa?
Again, there's evidence on both sides. FIT had emailed him. There was no further attempt to contact Mr. Rehife that he had read the emails. SCVP, the Student Exchange and Visitor Program, changed his information, made no effort to contact him, and then Mr. Rehife was able to obtain this hunting license. Yes, maybe there is some fault on Mr. Rehife. However, there's also fault on the government for not, going out of its way to make sure that Mr. Rehife knew of his status, and how Mr. Rehife was able to obtain the hunting license demonstrates that Mr. Heif did not legitimately know that he was illegal.
Well, counsel, understanding your argument that the government was not put to their evidence because the judge chose to instruct the trier of fact, they didn't even have to prove that element,
Yes.
the element of status. But isn't there longstanding precedent in the court that the government doesn't have to satisfy mens rea on a status element, just on a status element?
There are some cases where that is true. There are also cases where the court will read into a statute a mens rea clause, which is not even there in the statute. In the Flores-Figueroa v. U.S., which regarded identity theft, the Supreme Court declared that the government must prove that Flores-Figueroa knew he was committing identity theft at the time of the crime. So there's precedence that says that in some statutes the government doesn't have to prove that the defendant knew of the status. However, there are also cases that the courts read into the statute a mens rea clause. For example, in Staples v. U.S., there was no mens rea clause regarding that the defendant knew of the automation of his weapon. However, in order to protect the defendant, in order to ensure a valid and reasonable court case, they read into the statute a mens rea clause.
If we rule in your favor, will there be tens of thousands of people who've been convicted as felons in possession of firearms who now have a get-out-of-jail-free card because the government didn't prove that they knew of their status at the time of their conviction?
Regarding that statute of felons, there is no mens rea requirement. So there would be no cases brought up again requesting habeas because there is no mens rea. In this statute, there's explicitly knowingly before status and possession. So it's in the difference of the language of the statute itself. Moving on to my third point, in 1986, Congress created this statute, and it was an effort to consolidate 3 previous firearm-related statutes that did not expressly state a mens rea requirement. The problem was that many civilians, many people, were facing serious, severe punishments for unintentional missteps. For example, if we take dreamers, these people are brought into the United States at a very young age, 2 years old, by illegal immigrants. And they grow up in the United States being an illegal alien. One day, the government, the FBI, knocks on the door and says, "You're going to jail, you're illegally in the United States." However, they had no way of knowing this because no one had told them. It's because of this that the purpose of the statute was for Congress to protect these people. Was to protect people who did these unintentional missteps. Furthermore, in the legislative history of this statute, there is no indication by anyone, individual legislator or committee, that the knowingly requirement newly inserted into this statute was not intended to apply to a defendant's felony status. No one in the committee report or floor debate or in statements for the record said anything to the effect that this requirement should be understood to apply only to the conduct of the statute, which demonstrates, again, that it's there to protect unintentional missteps.
Isn't the immigrant's ability to be here based upon their status as a student, correct? So that's what brings them here legally. That's their privilege. Isn't it their burden to understand what their privilege is conditioned upon?
I agree. However, again, he was expelled from school. The school made a very small attempt to contact him. However, if he was able to purchase this hunting license, it shows that there's a problem with contacting the defendant because he was able to obtain it, demonstrating that he did not know he was illegal. And this statute states that the government must prove this, must prove that he knew he was illegal.
Counselor, excuse me, going back to your argument, understanding your position referenced the plain language.
Yes.
But now you hearkened us to the 1986 legislative dealing with the issue. And hasn't the case law since that 1986 decision reflected, many court of appeals have suggested that the court must only prove that the defendant is in one of these covered categories and that they possessed a firearm. So just prove they're in the category and they possessed a firearm and you've done your job on behalf of the government. Haven't some court of appeals dealt with it in that way?
I've agreed with that. Certain courts will definitely do that. However, certain courts regarding mens rea, that comes before status and possession. Also, in statutes where mens rea isn't there, courts will read into it mens rea. So there's precedence in that fact that it could go either way. It's up to the interpretation of the court. However, when the government instructs the jury to not have to prove that, to not consider this, it violates the due process clause, the right to a fair and decent trial.
Counselor, I believe your time's up. If you could conclude, please.
For these 5 reasons, the petitioner respectfully requests this court to overturn the decision of the Court of Appeals. Thank you.
Ms. Chief Justice, may it please the court. My name is Jasmine Lane, and I am representing the U.S. government in today's case. We respectfully request this court to uphold the decisions of the District Court and the Court of Appeals for the following reasons. First, the text of the law, quote, knowingly violence, applies not only to the defendant's offense conduct, but not his legal status. And second, the old statute has been required, has not been required a mens rea requirement, nor does this one. And third, it would be very hard to prove that the defense state of mind for the government. In July 2013, petitioner, a citizen of United Arab Emirates, received an F1 non-immigrant student visa to study at FIT. After 3 semesters, petitioner was academically dismissed. On January the 21st, 2015, FIT sent petitioner an email informing him of his dismissal and stating that his immigration status will be determined before February the 5th, 2015, unless the petitioner transferred institutions or voluntarily departed the United States. Petitioner took no action, and therefore his status was terminated. Later in the year, petitioner visited a shooting range and purchased a box of ammunition. Later, the petitioner had an interview with an FBI agent. When questioned by the federal investigators, the petitioner initially lied about his student status and falsely claiming that he had enrolled at a different university after leaving FIT. Following further questioning, however, Mr. Rehab admitted that he was aware that his student visa was out of status and consented to search of his hotel room, which turned out the remaining ammunition that petitioner had purchased. Following a jury trial in the United States District Court for the Middle District of Florida, petitioner was convicted on 2 counts of possession of a firearm and ammunition by an alien who is unlawfully in the United States.
Counselor, I understand that the petitioner might not be the most attractive person to be bringing this challenge to the statute, but our ruling is going to have far greater reach than just him. What is your response to the concern raised about the dreamer who might have a valid argument that they didn't know their status and the government seeks to prosecute them under this statute?
For the hypothetical situation of the dreamers, there are 2 reasons that the dreamer situation should not be applied here. First of all, the Congress could have amended the provisions, since there are many times for amendments to protect the dreamers if they have wanted to, but they didn't change the laws. And second of all, there's a situation called prosecutor discretion, in which the prosecutors could have changed their ways of determining the rulings based on different circumstances. And based on the text of the law itself, it shows that Congress did not want the government to have to prove knowledge of status. Section 92G, which the petitioner was charged of, makes it unlawful for people with specified background circumstances, including felons, fugitives, and aliens illegally in the United States, to ship, transport, possess, or receive firearms or ammunition in interstate or foreign commerce.
So just so I'm clear what your position is, your argument is that technically the Dreamers could be prosecuted, but we can hope there'll be prosecutorial discretion in the case.
Yes. And as a regulatory provision designed to keep guns out of potentially dangerous hands, Section 92G itself does not require any particular mens rea. Congress did include express mens rea requirements in neighboring regulatory provisions. For example, in 18 U.S.C. 92D, H, I, and J, which all incorporated the word knowingly or lawfully or willfully, some way or another, but conspicuously omitted one from this provision, which is Section 92G. If Congress had wanted to pull one there, it would have done so very easily. Someone's recklessness or negligence about his own status as a felon or an alien unlawfully in the United States does not exempt him from Section 92G's firearm provisions.
Well, the text of the statute does say knowingly violated, correct?
Yes.
So why isn't that the end of the discussion?
The knowing violence clause was in front of the 92G section, and I would argue that these are two separate provisions, which should not be both applied to the knowing violence. And plus, knowing violence only applies to the defendant's own offense conduct, but not his legal status.
But Counselor, aren't they both elements of that subsection? The plain language, they're both elements, the non-jurisdictional elements.
Yes.
So doesn't it stretch linguistic logic, as my fellow Justice Gorsuch wrote in the Gaines-Perez decisions? Doesn't it stretch our linguistic logic to understand that we're going to require that for one, but we're not going to require it for the second element when they're both in the same code section?
I'll agree with you that both of the elements are from one subsection. However, this court and the lower courts have always been interpreted of the subsection 92G, which does not require mens rea. And Congress enacted the FOPA Act in an effort to consolidate three previous interstate commerce laws. And while Congress did add the phrase knowing violence in part of the revised firearm laws, which was not in the penalty provision of the previous laws, it is well settled that absent a clear manifestation of contrary intent, a newly enacted or revised statute is presumed to have been harmonious with existing law and its judicial construction, quoting Johnson v. First National Bank in the United States. And in other words, courts should assume that when Congress revises the law, that it did not intend to change the previous judicial interpretation of the law, absent clear evidence to the contrary. In fact, when Congress enacted FOPA in 1986, it did not know how courts had interpreted the previous law. In a report discussing the Senate's proposal, the House of Representatives described its understanding that current case law interpreting the criminal provisions of the Gun Control Act has required that the government prove that the defendant's conduct was knowing, but not the defendant knew that his conduct was in violation of the law. And moving on to my third point, petitioner's contrary interpretation disregards the statutory structure and would transform firearm possession trials into extended explorations of the unattractive details of the defendant's past. If the continuation of pre-existing practice were in fact the opposite of what Congress had intended, its 1986 enactment to accomplish it would presumably have addressed such a severe misunderstanding in one of many amendments that it has made to Section 92 and 94 during that time. At the same time, direct evidence of a defendant's knowledge may be complicated to be presented at the trial. In a typical criminal prosecution, knowledge or intent can be inferred from the circumstances of the defendant's offense conduct. For example, proof that a defendant stole a television that did not belong to him will in itself tend to prove his intent to steal. But that is not the case. With respect to proof of a defendant's knowledge of his personal circumstances or legal status, those attributes of a defendant are unrelated to his own offense conduct. Proving knowledge can be difficult.
But Counselor, while it may be difficult, it's the burden on the government. The individual is innocent until proven guilty, and when the plain language requires both aspects, is it not somewhat the government saying this may be just too hard of an element for us to prove case after case, therefore we don't want to be held responsible for proving it?
Even the petitioner's reading of the statute is correct, it was harmless error in today's case. Petitioner, for example, applied for a non-immigrant student visa, which here he signed a form or a contract attesting that he understood the terms and conditions for him to study at the United States. And he underwent an interview with FBI at a United States consulate in order to obtain a visa and receive notification from his school after he was academically dismissed. So for all of the facts that I just mentioned, it would determine that in this case, it would be harmless error for the petitioner to whether knowingly or both, the knowing violence applies to both of the statutes. And what's more, in Cheek, the United States, the principle that ignorance of the law or mistake of the law is no defense to criminal prosecution is deeply rooted in the American legal system. Also in Cheek, it is specifically stated that based on the notion that the law is definite and knowable, the common law presumes that every person knew the law. Therefore, the notion of Mr. Hyde as an alien who can be excused from the possible ignorance of the law.
Counselor, is this ignorance or mistake of the law, or is it a mistake of fact?
Mistake of the law can be mistake of fact sometimes, and I don't think mistake of fact should be here as an argument to apply in today's case. Mr. Hyde is an alien, but he should not be excused from the possible mistake of the law. And therefore, for the reasons above, the decision of Court of Appeals should be upheld.
Chief Justice, I respectfully request this court to overturn the decision of the Court of Appeals. The courts have instructed Congress constantly to say what it means and mean what it said in regarding statutes. The courts cannot edit Congress's laws, they can only interpret them. And when those laws are made clear, they can only enforce it. Now, if the court is not satisfied that this statute is not clear, I'd like to point out that the interpretation of the statute should favor the defendant. In the case of Liparota v. U.S., the mens rea clause was also at hand. The court was confronted with two options similar to those in Mr. Hyde's case, and it chose the option that was in keeping with the long-standing recognition that the principle of ambiguity regarding the interpretation of criminal statutes should be resolved in favor of lenity, meaning that if there are two interpretations of the statute regarding an ambiguous statute, the court should choose the interpretation that sides with the defendant. For these reasons, the petitioner respectfully requests this court to overturn the decision of the Court of Appeals. Thank you.
Congratulations to all of our lawyers tonight. You all did an amazing job, and the justices have a very tough decision ahead of them. And thank you all for coming out tonight and supporting these 5 students who have dedicated a huge amount of time to doing this endeavor. I am sure they're very appreciative of your attendance as well. Drive safely, don't drink and drive, and hope you all have a great rest of your week. Thank you.